Okay, I see I'm unmuted. Thank you for coming to this webinar. Today, you're going to get to know a little bit about what probation is and how it works at Seattle Municipal Court. We're also going to give you updates on our probation evolution project. Let me introduce myself. I am Judge Faye, and I am the incoming assistant presiding judge. I've been here at the court for a little over 4.5 years, and prior to that, I was a magistrate. So I'm going to let Carol Bell introduce herself when she gets here. So we're going to just go through the slides now. Our mission at Seattle Municipal Court is to provide a forum to resolve alleged violations of the law in a respectful, independent, and an impartial manner. We are the judicial branch of city government with 7 elected judges and 5 appointed magistrates and a highly dedicated group of staff. We handle all misdemeanors and gross misdemeanor crimes and civil infractions under the Seattle Municipal Code and certain RCW statutes. We're the highest volume court of limited jurisdiction in the state. We process thousands of criminal cases and hundreds of thousands of vehicle infractions every year for the city of Seattle. We started our probation evolution project in 2020 at the start of the pandemic. Our court has changed a lot since then. One thing that has changed is the development of a set of organizational values. Our judges and staff work together to identify and build a shared commitment to the court's values. The 6 aspirational values we adopted are service, fairness, equity and inclusion, innovation, excellence, and integrity. These values will guide all of our work, including our organization's strategic planning. Okay, so before we update you on our probation evolution project, I want to share some information about how our system works at SMC. And this is not just at SMC, a lot of other courts have a probation system. So this may pertain to other court systems that you might be familiar with here in the state of Washington. There are a lot of steps that happen before a person comes to probation. Before a criminal charge enters our court, first, a crime is reported to the Seattle Police. Police refer the charge to the city attorney, and the attorneys there decide whether to file charges. Once a case is filed with the court, then we hold hearings to resolve the case. Probation is assigned after a case has been adjudicated. So let's talk about, and this is really into Carol's lane, but I'm going to start since she's not here. So give me some grace because this is not in what's something I normally do is talk about probation. So I'm going to go ahead and take a stand at it. So let's talk about what is probation at Seattle Municipal Court. And just give me one moment. Like I say, give me a lot of grace here. Okay, so probation is a post-adjudication or post-trial case management program. Many cases in Seattle Municipal Court never come to probation. The case might get dismissed or resolved in some other kind of way that does not involve probation as part of the sentence. If a person is found guilty of a crime, then they may be assigned to probation as part of their sentence. At sentencing, a judge may order several obligations for a person to complete. These obligations are often negotiated through agreed orders or plea agreements between the city attorney, the defense attorney, and their client. For example, someone who has committed a domestic violence offense may agree to participate in a domestic violence intervention program that includes treatment. Probation staff rarely weigh in on what the sentencing obligation should be. The probation counselor's role is to support a client in a successful completion of court order obligations, help them achieve self-identified goals, with the goal of transitioning them out of the criminal legal system. And I really want to kind of emphasize that is that probation is a way, our goal, I can say this on all of my colleagues, is that our goal is someone not remain in, as I call it, the system. That we want people who will move out and move out of the system and have supports in the community so they won't transition back. I think I now see my co-presenter, Ms. Bell. I'm going to ask her when she gets her camera adjusted if she can introduce herself and then talk about why probation evolution.
Hi, Judge Chaston. I've been having technical difficulties all this time. So I do apologize. Yes, I am Carol Bell, and I am one of the managers in our probation department. And let me tell you a little bit about why probation evolution. So we started this, our goal with this project really was to reimagine what we could do with probation. We seek to transform our programs and services division by really stepping away from the traditional model of probation and looking at how we can meet the needs of the client where they are. Sorry, Judge Chess, I continue to have some technical difficulties on my side. We seek to be transformative in our programs and services division by stepping away from traditional incarcerative, reactionary approaches to misdemeanor supervision. And we really want to move towards this model where we're hopeful and we're equitable and supportive in our client service delivery model. So what you'll be seeing is us really focusing on our goals for the clients, and what we seek to deliver in that is really meeting the clients where we are and helping them to shape those goals in the early stages of probation.
So Carol, do you see we're on the next slide?
I'm sorry, my.
Okay,
okay, here it is, right here.
Okay, because I said
I am so sorry for our challenges today. So where we are, we have previous community feedback that led us to where we are today. Our probation program did some assessments and some surveys. So we had the Vera Institute of Justice did a report with Seattle Municipal Court Probation Services on strategies for improving our policies and practices in 2020. We also had an audit that was completed by the City Auditor's Office, and this really focused on the racial demographics and the ethnic disproportionalities that maybe have came out of probation. Then we did client exit surveys. This is something that we started a little over 18 months ago. Really, all the clients that were coming through on probation, as they closed out their probation, we would send them a link and give them an opportunity to give us feedback on their experience with probation. Then we did some court-wide assessments, and that happened with the VITA agency. The VITA agency is a community-based agency that's right here in Seattle. They're a nonprofit, and this work was really focused on how are we as a court addressing the users as they come through the doors. We did focus groups, and then that resulted in a recommendation report that also came out in 2020. Finally, the court users access and fairness survey. This was distributed to court users in person and online. We worked with university volunteers and court staff to meet clients as they were coming through the courts and did surveys with them about their overall court experience. All of this can be found online. As you see, the ones that are related to probation evolution are on seattle.gov/courts probation evolution. And then the court-wide assessments are on seattle.gov/courts/community-engagement. So let's talk a little bit about what's really changed for us. We've taken the time to really focus on high-risk probation cases. This really starts from our bench, our judicial officers. They have made a commitment to refer cases to probation that are DUI, so that's driving under the influence, domestic violence, or mental health court track clients. With this, the active number of clients by probation unit as of June 2022, as you can see, we have 832 individuals that are on active probation. And I'll just we have our central unit, the domestic violence unit, the driving impaired unit, and the mental health unit. What you'll see with this is that we're spending the time really focusing on those individuals that are coming through and they are identified as high risk. So all of our energy is focused on those clients that are reporting in need of those type of that have that case type and then have need the services related to them. Next, what we've done is we discontinued the practice of criminal record checks for clients not referred to probation. Right here, you'll see that previous to this change, we had clients that were on probation for a period of time that completed their active conditions, and then their case would be closed. That case could remain on active probation just for monitoring for new criminal law violations. We no longer do that. So if a person completes their active conditions, we submit an order to close to the court. The bench is also committed to not send any cases to probation only for criminal record checks. The next change that you'll see is we've eliminated discretionary probation fees September of 2020. This was an order that came from our judicial officers of the court to no longer impose any discretionary fees. So that could be a fee for being on probation, for community service obligations, for work crew, or a record checks fee. You'll now no longer see those being imposed. The next change we have is the case closure policy, which I referenced earlier in a couple slides. So not only are the judges not sending cases to probation that are to be monitored for criminal record check only, but we have the case closure policy that was adopted, which means that, as I said, as soon as a person is done with their active condition, so if they're referred to probation and they're to do chemical dependency treatment or domestic violence treatment, as soon as that treatment obligation is closed out, we will close out their case on probation. Another thing we did is we responded to a really important part of what had came out of the audit in the information from the Vera group, which was we began collecting client-reported race and ethnicity data. This had previously been a challenge for us as we relied on other criminal justice agencies to report in this information to us. Now, as a client comes in, they have the opportunity, as we have this information on our forms or a area on our forms to actually say what race they are or ethnicity group that they identify with. And we're keeping track of that information so that we can be able to report it out. All of this information, again, you'll be able to find on our court's website. Then as I said, we implemented our client exit survey. This gives an opportunity for the clients to share out their experience on probation. This client exit survey was designed by a group of staff, service providers that are community-based, and former probation clients. So as a group, we came together in 2020 and designed a survey that really gets at the heart of their experience and gives them an opportunity to share back whether it was the obligation that placed them on probation or their experience with their actual probation counselor. And finally, one of our most landmark changes that have been implemented is the elimination of the risk assessment tool. This was something that Judge Gregory, our presiding judge, took the initiative in deciding that we were going to make this change as a court. We looked at the impacts of our risk assessment tool and the information that was gathered through these different audits. And we decided that this was not the way to best serve our clients. Judge Gregory made this decision as our presiding judge, and we as a court have wholeheartedly gotten behind this. In replacement of this risk assessment tool, we have a team that has been working to design a new classification system that really gets at how can we best support the clients and how often we need to be engaging them in their process, in their term of probation. Other changes that you've seen or we have seen at the court in 2022 so far is we've hired a probation evolution project manager. This is an organizational change manager that has really helped us to hone in and drive this process forward. We've developed a project schedule for implementing all probation evolution tasks. We expect this to be completed by the end of the second quarter in 2023. We've arranged a division-wide training on trauma responsive care. We've done harm reduction and motivational interviewing will be coming in summer of 2022. We've also hired a community outreach and engagement strategic advisor. Her name is Victoria Moreland, and she has been great. She comes with a wealth of experience and has so many great ideas on how we can engage community in a very thoughtful and meaningful way and take this information and apply it to how we will move forward in our vision at the court. In our court's resource center, we have welcomed a systems navigator. This was something that came out of the budget in 2021, and we are excited to have a partnership with the YWCA. We have an individual, Nicole, that serves as our systems navigator. She's at our resource center 3 days a week. We are operating Monday, Wednesday, and Thursday, engaging clients and anyone that enters the doors of the court that need to be in support with being hooked up with social services, hygiene kits, backpacks, treatment, you name it. We are there to support them in the Court Resource Center. So looking at our project plan, as we've kind of shared with you, here we are, spring of 2022. We're in the midst of the development of a new classification system that will determine the probation client's initial reporting frequency and how we'll be engaging the client. In that, we're looking at our intake policy and how we're going to assess the clients as they're initially placed on probation. Summer of 2022 will be in the second phase of our release. This is going to stretch through September. The new classification system will determine the client's reporting and ongoing frequency. We'll be doing pilots within that time. Fall of 2022, we get really deep into our releases. We go department-wide with this. You'll see supervision changes that include positive reinforcement to encourage clients to achieve pro-social goals. You'll see our probation counselors putting a lot of training that they've been going through into action. In phase 4 of the release, winter of 2022, you'll see that our supervision model will start to include incentives. Our hope with this incentives is it's really going to reinforce the client's positive outcomes. We really want to encourage them, and we want all of this to be informed by key performance measures. Spring of 2023, phase 5, really the conclusion of our probation evolution deployment. You'll see processes and policies being implemented. You'll see performance measures being reported out in the forms of, we'll be taking that information and reporting out data. We hope to be sustainably engaging community and working on continuous improvement of our probation services and our delivery of our services, how we engage our clients, the support of our probation counselors in training and other things, so that we know we are providing the best possible product to the clients that we're serving. Now, we'd like to welcome any kind of questions you may have. If you want to drop those in the chat, we're excited to hear from you.
Thank you, Carol, and thank you, Judge Chess. We do have a couple of questions in the Q&A right now. First, we have 2 kind of related questions. We've got, if active probation is closed, but there is still jurisdiction, how is the court notified of new law violations? And then the follow-up to that is, for example, a domestic violence case where the case remains open for the condition of no contact order. Is the no contact violation condition dropped when the probation closes the case? There's some acronyms in there.
I guess, let me take that. So when active probation closes, as you've already been told, is it doesn't end what do you call it, jurisdiction. So what happens is if a person has engaged, and these are allegations, in a new criminal law violation, most of the time the prosecutor will file a notice of probation violation or notice of violations, conditions of violations. And then that a hearing gets set, a review hearing, to address whether or not the person has in fact committed the new law violations. Now, and this is just like in real time, is what sometimes happens is we become aware because a person gets arrested on a new criminal law violation that actually is in our court system. So if I'm the judge on a jail calendar and a person is arrested and we are aware they have a pending case in Seattle Municipal Court where jurisdiction is still open, then that judge will go ahead and track that new case with the old case. And then the city will then file a notice. So sometimes we know before the city does, or we know at the same time, because again, that person's got a new charge. No contact orders have like a life of their own, meaning is they have their own jurisdiction. So no contact orders can last longer than actually the case is open. So I want to get that clarity. You can have somebody who has a no contact order, but they were on jurisdiction for 2 years, but that was a 5 years no contact order. That no contact order will stay out there. But in regards to the court addressing it, yes, the court, if there's a new law violation, the city would notify the court and then the parties would have a discussion about that, even though active probation has been closed.
Thank you, Judge. We have two questions that are similar. What kind of incentives are going to be offered? And is it possible to get some examples of incentives that you will be using? And Carol, I don't know if you want to speak to this. I think we don't have a full answer to that question yet, but I'll let you go ahead.
Actually, we don't have a full answer to that question. I know we are investigating what types of incentives actually will be meaningful, and that is part of the importance of our community engagement efforts, is talking to former clients to see what type of incentives are meaningful. I think our biggest incentive that we really talked about is closing out probation as soon as possible. But we want to do other things that are positive reinforcements along the way. We've had other opportunities, like with our mental health court program and our community court program, where we've offered clients gift cards to like local businesses like a Safeway to be able to, or Goodwill, where they can get things that would help them with their daily living, or if they are trying to get resources to get back to work. There are things that we don't have in the resource center that maybe they can get through a Goodwill voucher. So these are things that we are looking for, or looking into and exploring as options in how we can properly incentivize those that are in probation or on probation.
Thank you. Another question we've got, do you consider victims of crime to be stakeholders? If so, how are they engaged in the development of this evolution plan?
We definitely consider victims of crimes to be stakeholders in this, and we invite them in the community stakeholder engagement focus groups. So we're looking at opportunities in that to hear from victims, and we are working with some of our domestic violence victims advocacy groups to make sure that they have a voice at the table as well.
Thank you. I don't have more questions in the queue just yet. See, we have a comment saying many of the clients we serve who are also on probation have trespass orders from a number of local stores, for example, Target, Safeway. So gift cards to specific stores can be problematic or have been problematic in the past. Visa gift cards have been a great workaround to this. So that is a piece of feedback, and thank you for that comment as we're working on developing a plan for incentives later in the year. If others have questions, please feel free to submit them in that Q&A.
And one comment that I did get from one of my colleagues that I want to be able, I believe is important to share out with the individuals is when we talk about closing out probation, we talk about the active piece of probation. A client may still have open jurisdiction with the court. So we really want to be clear on that. They won't be required to report on probation. They'll no longer have that obligation. But if they do, as Judge Chess had referred to, like have a no contact order or have other obligations like that that are not under the umbrella of probation, they are to adhere to that. So as long as the jurisdiction remains open and the condition is no new criminal law violations, then that individual is held to that. And it is on the city attorney to actually file that for it to come to the attention of the court. It will not be probation services that is monitoring them for that.
Thank you. I see Another question, how does probation and the court balance the support that the defendants want and need to change with the accountability that victims are craving?
I guess that will fall probably back to me is, and remember, we're all independent judges, and so each judge handles their courtroom differently. And I have actually not been in any of my colleagues' courtrooms to see how they do sentencing. So I'm going to speak just for myself. For those who are in this call who may have been in the courtroom when I do sentencing, if the victim or victims present, I listen to them. I also ask every person that I sentence to tell me what they would like me to consider before I impose sentence. And if they don't, I tend to do queries, ask them questions to get a really good understanding of how they ended up here. And I also ask them questions about what are they wanting to do after they get out or after this sentence is done. What's their future look like? And I keep all of that in mind when I am thinking about what a sentence should be and how long the court should have jurisdiction. I will tell you, for the most part, most judges follow the parties' negotiated sentence recommendation, which includes jurisdiction, how long the case should be held open in case a person has a violation of conditions. Typically, you see 24 months, and then on DUIs, 5 years. That's kind of the typical range. But sometimes a judge can deviate from that. I have deviated in the past. I might impose a deferred sentence when the party said, hey, we wanted 2 years for this case to be held open, and we want to show a conviction at the end. If I hear something compelling and that person has lack of history, or even a history where I know that the impact of another conviction could negatively impact them more than what the parties were intending, I might offer deferred. Or I may do a deferred sentence for less than the time period they wanted, because this person has progressed or done things before this case came to sentencing. So for me, it's an individual case. I listen to everyone and get everybody to weigh in. And then I look at what information I've been given and to decide. I will tell you that even if a case is open for 24 months, meaning jurisdictions for 24 months, there's nothing that prevents a judge from closing jurisdiction early. We have had times when people have really gone beyond what was ever expected. It's like it makes no sense to keep holding this case out. And so we'll close it. We do get input from defense and the city attorney as to their thoughts. But again, we're independent judges, and we at the end make the final decision. And nothing is, let me just say this, is cookie cutter. Sometimes people want to say, well, if these facts happen, then you'll do this. No, each case is different. Each human being is different. Each reason why they show up in the court system is different. I think that as judges, we're getting better understanding of trauma and how trauma plays a part of why people show up in the criminal justice system. We're also getting a better understanding of trauma from victims. And so one size does not fit all for all cases. And again, you look at where that person is at when you decide jurisdiction, and you decide later if jurisdiction needs to remain open. Let's talk about, for me, probation. And as I tell, again, if you've been in my courtroom, you've heard me say is that the reason I will put somebody on active probation that's not required. So DUIs, active probation is required. If there are conditions like they have to get a chemical dependency evaluation, do follow-up treatment, automatically active probation is going to be set on that at the time of sentencing. If a person has completed treatment or completed the evaluation and no treatment is recommended, I probably will not put them on active probation, because there's nothing for them to, again, actively do. But going back to the generic case, let's say it is property destruction and I put them on active probation, most likely is because I've ordered them to get some type of assistance, some type of treatment. We may have gotten information that that person is engaging in the behavior because there's some substance abuse. And so when I refer people to probation, what I'm looking for is for them to get support. A lot of times people can't do things on their own. They cannot get the services they need on their own. And so I see probation as a method to give them tools and information and assistance in getting the things they need so they won't come back into the court system. I think we've all can see that just posing somebody to jail time is not effective. It's just not. And so probation is that place I go to say, hey, you need some help. These people can help you so you won't come back here. I think my goal is kind of put myself out of business if it is done right. So hopefully I've responded to those questions and maybe some others you might have had.
Thank you, Judge Chess. Yeah, if others have questions, still feel free to put them in the chat. I'm kind of curious, we talked a lot about probation evolution, how we expect to finish the project next year, Q2 of next year. And Carol, I'm curious, like just at a high level, like what do you think are some of the bigger differences that people would see once we've completed the project? And I know we're still designing a lot of things, so we don't know exactly what it will look like. But if you were going to summarize what that looks like.
Well, we've started with a lot of, we started right away tackling things that I feel like were easy wins, but important. Keeping people on probation longer than necessary is something that we don't want to do. So being able to close them out as early and quickly as we can, trying to limit their intervention with the criminal justice system, I think is huge. So we'll definitely have smaller caseloads resulting in that. And what it does for a probation counselor is it frees up time for them to really engage those that are high needs or come in and identified as high risk. That's really one of the goals of this, is to give the individuals that need the attention they need, really connecting them with resources, treatment, and other services. I mean, you know, if we have the grand package, we'd be able to just put somebody in treatment, give them housing and meet everything, and we'd have, you know, free flowing money to make all this happen, but we don't. So we're working within the confines of what we do have. And that means as soon as a person's getting engaged, getting referred to probation, we're really going to put the effort forward in engaging them in a meaningful way, starting with the intake process, asking them questions that really get to the heart of their issues, that are not just about the probation obligation that was set before them, but what are barriers to getting them into a better life condition. So we're going to be engaging individuals in a new, more welcoming way, I believe. We have some probation counselors. All of our probation counselors are really committed to the work that they're doing, but a lot of them needed more training. They came in and a lot of them, they're all required to do a basic level of training, but some of them have been in the industry for a really long time, and all of them had varying degrees of experience and knowledge. And so really pulling that together and bringing in things like trauma-informed care, harm reduction, and making sure that they are adequately trained in that area to be able to see different signs with the client or engage them with the resources that are out there. So those are things that will happen more on the front end, I believe. And then we'll just really have the opportunity to, as they're moving along the spectrum, address things like their violations in a meaningful way. We don't want, like we said, to be stuck in this incarcerative model, but we really want to do meaningful engagement. So if that means offering a person life skills as an opportunity to address what's going on with them so they can really work through some of those thinking errors, then let's get them in a life skills class. If that means restarting treatment, working real intimately with the treatment provider, then that's the work that we're going to do. I'm not saying it's not being done now, but we've had larger caseloads where we didn't have the capacity to deliver that work at the same volume. And now we're seeing the opportunity to be able to do that, because those that don't need the time and attention, they're not going to be on probation. They're going to come in, get their obligations done, and close them out. We won't see them on this long, drawn out spectrum of being engaged in the criminal justice system.
Thank you. That's a great answer. I don't see any more questions in the Q&A. I wonder if audience members, if we have a question for you. I'm curious what brought our audience members to this presentation, what they were hoping to learn about, and what they would want to learn about in the future. So if you want to answer those questions and submit them to the Q&A, that would be great information to have. And we can plan a future event or webinar.
Okay, so looks like we got a couple of questions. Have we seen more drug charges since they are no longer felonies? And second one is, can you explain the criminal records check more? How is it functioning? How was it functioning previously, and how will that function now? I'm going to let Carol take the criminals records checks as far as back in the day and what it looks like now, but I'll talk about drug charges. I would say, so for, again, everybody who knows me, I tell people I've been working in the criminal justice system now for over 30 years. I started out as a public defender, and over time period, the changes, there have been less charges as the community has embraced that some charges are not, should be criminalized, like the marijuana, possession of marijuana. As many of you might know or recall that we had people who had been previously charged with convictions for possession of marijuana, and this court vacated those convictions, which meant we removed them off of their criminal record. And I would say is you don't see as many. Over time, over these 30 years, much lesser charges, because we are a court that deals just with misdemeanors. And once marijuana possession was no longer being charged, yes, there was a substantial drop. You'll have to ask Superior Court judges about possession of what they call VUXA, which are controlled substances like cocaine and marijuana and things like that. Now, I will tell you this is what I'm seeing, and I think some of my colleagues are seeing. Because of the rise in addiction to meth and fentanyl, we are seeing many more DUIs where the allegations are the person was under the influence of drugs versus alcohol. Many more. Used to be when I would have search warrant duty, and for those who don't know what that is that means we get calls overnight from police officers asking us to sign off on blood search warrants, meaning they would like to search the person's blood. And as you all know, you can't determine if somebody's consumed a drug by BAC machine. That's only for alcohol. So because of the person's conditions, they will ask if they can have a blood search warrant. And I will say is those have gone up drastically. And as just a person who lives in the community, it's very concerning the number of people who have become impacted by these type of drugs. And that as a community member, we've got to do more in engaging how to prevent the addiction. And then once a person is addicted, what kind of, getting them into treatment. So from there, I'll give it to Carol on the records check.
So the way that we did records checks in the past, an individual either was referred directly from court for record check only. So that meant their case would be monitored by the probation department every 3 months. We'd run their criminal history nationwide to see if they had any new criminal law violations. If they got a new criminal law violation, a report, the client will be notified and a report will be submitted to the court in the hearing set. They would have to come before the judge to address that new criminal law violation. If a person was referred to probation for other probation conditions, we would do record checks at the same cadence. But once they completed all of their active conditions of probation, so if they had to do treatment or a victims panel or some other form of engagement where there's an active condition, then they will be required to do that. And every 3 months, again, at minimum, we're doing a record check. Sometimes that's happening once a month, depending on how often we're engaging the client. If we were to get become aware of the new criminal law violation, at that point, we would again notify the court, notify the client, and they would have to come before the court for a hearing to address the new criminal law violation. Once they completed their active conditions, we transferred them to a bank where we would continue to run the record check report every 3 months. The difference in this being now that if a person's referred to probation, they've completed those active conditions like a victims panel or domestic violence treatment. Once that is completed, we close it out. We're not running their background to see if they have any new criminal law violations. And then on the other hand, the judges aren't sending any cases just to be monitored for that as well. The only exception that you're going to see for that might be for a DUI case where there may be some other ancillary conditions like ignition interlock device requirement. And we do verify the ignition interlock installation and monitor the ongoing reports associated with that, as well as deferred prosecution cases where there was an agreement for that client when they went into a deferred prosecution, and that requires a minimum of 2 years of treatment.
So I see there that one person wants to be able to give accurate information or accurate analysis to their program staff and participants about what they will encounter in SMC probation supervision. So I'm not sure if it's a question or not, but I think this is what the purpose of this presentation is to give insight of what people should expect moving forward from engagement with probation. Wouldn't you say, Carol?
I agree with that. Some of the things that you're going to see along the next year is you're going to see information about the work we're doing on our court's website. So while this is just really a snapshot into what is happening right now and our forecasted timeline, we'll be reporting out data and some of the changes. So we encourage you to check out our website. We also encourage you to just reach out to staff. We want to be really transparent in what we're doing and how we're moving forward. The probation managers, and all of our staff are actively engaged in this. We're working with partners such as the Office of Civil Rights in helping to consult and how we move forward in engaging community and making sure that we are looking at everything through a race and social justice lens. And all of our business practices are in alignment with that. So we encourage you to just continue to look at our website, continue to be a part of these conversations as we're having today, and encourage your staff to attend as well. Judge Chess, I see after that, we have another question. What about shoplifters that are repeat offenders? They have SUD needs, but refuse treatment and continue to reoffend to support the habits.
So I take that more as a statement than a question. I will say that what my understanding, having worked in so many varieties of public service, what I will say is that we all need to recognize that first, that people who have substance abuse issues, one time in treatment is not enough. Second of all is that people may not be in a place to receive the services they're getting the first time, maybe not even the second time, maybe not the third time. When you look at a lot of the individuals who have substance abuse problems, there are other problems that are attached: the housing, the lack of employment, disconnection from family and friends. There's so many things that play a part of why we're seeing people who are repeat offenders. As the economy gets worse, people who may not have ever engaged, doesn't have substance abuse, but never have engaged in criminal behavior, feel forced to have to do it because there's limited resources. I think the goal for all of us who care and who work in this environment is that we want people to have support and to not cycle through the system. And we need to give grace. Understanding is that they may need more support longer than someone else. It's just depending on facts and circumstances and where they're at. But that's kind of our goal, to work ourselves out of this system. You know, it would be nice to close it down. Another person wrote that that they're a victim advocate supervisor, and they are always interested in the details, nitty gritty of how things work so they can answer victims' questions. I also heard a lot of frustration for victims about how supportive the court is to defendants and how long it takes, if at all, to get a violation addressed. Says, I understand the concerns regarding equity and that defendants do need help and have trauma, but I think the victim's experience needs to be more present in the court, even though the victims themselves often do not wish to participate. And I think you're right, from this person who wrote this, is that victims do play a part in the conversation. I am respectful when a victim does not want to speak, but would like the victim's advocate to speak on their behalf. I try my best in court to always, if I know they're present, to allow them to speak, even if it's the first hearing. So if they show up at any of the hearings, pretty much except for pretrial hearings, which are just basically more administrative, deciding which way a case will go. So you don't see victims on that calendar. But first appearance, sentencing, if they appear, I'll hear them out, because everybody has been adversely affected. It's not just the defendants we need to be listening to. We also need to listen to the victims. I will say we've got a wonderful acknowledgement from the city attorney's office, and I think we all, the entire community, when I say community, is we're all partners, right? We're separate branches of government, but we are partners. We have stakeholders. I don't see adversaries. I see people who are trying to do their very best, whether they're the defense attorneys, whether they're the city attorneys, or whether they're the judicial branch, to make it a system that's equitable and fair. Because at the end of the day, what I say to people is, you might not have liked my decision, but I hope you know why I made the decision I did. And that you, when you came in front of me, you felt you had a voice, whether you were a defendant or victim or counsel, that you had an opportunity to share your side. And that when I render my decision, it reflects that I heard. Okay, how are you all addressing the lack of trust your clients may have with getting resources with probation officer, given the history of the harm this system has caused? I think that's a Carol question.
As we're getting closer to the end, that's a really, I think that kind of gets at the heart of where we are right now. There is a lack of trust in the community, with our clients, even with just the overall criminal justice system. And how we start to build back trust is through transparency and showing up and having the resources available. One of the things that we learned early on, even in the development of our building, is the value of having a resource center. But over the last few years, we put I'll say we put our money where our mouth is in ensuring that we have a resource center that has resources tangibly ready for the client that comes in. We know that's the beginning part of really building trust is early on in a relationship, being transparent, letting the client know what to expect when they come to probation. We're a client, what you're going to see implemented along the spectrum of services. We don't have the actual date, but we will have a client bill of rights where the client will be explained what the expectations are, what their rights are, and how empowering this can be for them, how they need to, how they can show up and how we'll show up, and holding us to those expectations. The clients will also have an opportunity, not just to do the exit survey, but to do a feedback form. So if they have, things that they want to follow up with, if they have an issue as probation is going along, not just at the end, they have a forum to have a voice and know that we will be responding to them as managers, as their probation counselors, in a meaningful way to say, okay, hey, what's going on? And why are you unhappy with where we are in the process? Or what is good about what's going on in the process? And how can we build on what's good? So part of trust comes through time. It comes through being honest. It means showing up as much as you can, with as much as you can, to give the clients what they need. We know it's going to take time to change the face of what probation looks like to those that have come through our doors in the past, those that have had experiences with other entities. Some people come into our offices and they've never been on probation with us, but they've been on probation with the state or in another state, and they've had a really bad experience. So we have to be cognizant of that and how they show up in that. And that's why it's important for us to do things like trauma-informed care training and looking at what we can do to really meet the client where we are and understanding how they've been harmed by past engagement in the system. And I see
we're going to wrap it up at this point, Carol, because we're running out of time. So we do have a few more questions that have been posed. And what we're going to do is, and they're really directed to Carol. So I think Carol's got a little bit more work to do to answer these questions after we finish this session. And what we're going to do is post the answers to the questions afterwards with the recording. I know I want to say on behalf of the bench, thank you for allowing us to talk and that you showed up to listen to us and ask really thoughtful questions. I know I'm taking something away from it, and I'm going to talk to my colleagues about the things I've learned through this session. Carol, I'll turn it over to you.
Yes, I've really appreciated this time to engage with everyone. I really appreciate you all's patience with my technical difficulties today. And I look forward for the opportunity for us to continue this conversation. Like I've said along this is just the beginning. This is just the beginning for what you'll see in the changes in our department, changes that are happening court-wide, how you'll be seeing us show up as probation counselors, how you'll see us in the community. And we want you all to be a part of that process of change. So give us your feedback, keep talking to us, show up for our focus groups and other community engagement opportunities. Check out our website so you can continue to be informed on what is happening and how the changes impact you and the community around you.
And with that, I think we'll say goodbye.